नमस्कार, आर के त्यागी गाजियाबाद एनसीआर दिल्ली ओम सच्ची जनवानी चैनल पर आपका स्वागत है। चैनल को प्लीज़ सब्सक्राइब करें, आपका 1 सेकंड खर्च होगा। हमारा प्रचार होता है और चैनल का विस्तार होता है। वीडियो को शेयर, लाइक, कमेंट करें। शेयर करने से सभी साथियों तक जाती है वीडियो और ऑल सेक्शंस ऑफ सोसाइटी, ऑल सेक्शंस पॉलिटिकल पार्टीज तक जाती है, गवर्नमेंट और सब रिटायरीज तक जाती है। व्यूज़, इशूज़ और न्यूज़ रिटायरीज के प्रसारित होते हैं और रिटायरी साथी मोटिवेट होते हैं। आइए शुरू करते हैं। ये हमारे मिस्टर रमेश भटेजा जी हैं, सीनियर एक्टिविस्ट हैं हमारे साथी और ग्रेजुएटी रिकैलकुलेशन में हमारे केस में भी हैं। 2006 के रिटायरी हैं SB बेजे से। तो आइए, इनका एक पोस्ट है, अच्छी लिखी है इन्होंने, वो मैं आपको अवगत कराता हूँ। फ्रेंड्स, these days it has become a practice for the trade unions to sign the BPS according to their convenience, setting aside the pension regulations and statutory provisions, and they do not feel that our existing rights are protected by such agreements. Number one, I have an opportunity to discuss the above problem with one more senior activist who was the president of legal committee formed by AIRBEA in 2000 and who was main architect of preparing and filing the writ petitions relating to 7th BPS anomaly of 1600-1684 DA, on which judgment was awarded by Supreme Court on 30th February 2018 in favor of the Pensioners Association. Number two, that was a brief discussion on the subject matter, and he asserted that at the initial stage when it was agreed between IBA and unions that the pension regulation will be the replica of central CCS pension rules 1972. The IBA and the unions were assigned the job of summarizing pension regulations of 1995, keeping in view CCS pension rules with mutual understanding. It was summarized by them and submitted to the government for approval of the parliament and notification. Number three, IBA and unions carried a misunderstanding that they are the rule makers. After notification, they got no right to discuss or amend because after forming the act, their job is finished. Number four, now they are not authorized to amend any of the provisions and take away the benefit and the accrued rights. It was with duly confirmed by the apex court in their decision dated 30th February 18th, wide paragraph 29 to 33. Fifth, he further quoted that the provision of Article 19 of the Constitution of India, wherein the purpose of forming the unions has been exolcined. He further quoted that leaders of the unions were elected for the purpose. They have mandates only for the improvement in pension regulations and to safeguard the interest of the members in implementation of statutory provisions. Sixth, today I studied the judgment dated 13th February 2018 of Supreme Court and found various observations while giving the final judgment. My observations are based on the discussions with him, and these are enumerated hereunder. A. The burning example is introduction of special allowance in 10th BPS, which was intentionally introduced to reduce the basic pension after retirement. It is absolutely against the principles of trade unions. B. During 7th BPS, the DA for the pensioners was fixed 1616 CPI points instead of 1684, and it was illegal, and hence it was struck down by Supreme Court, and as such the 68 points of DA were released with arrears and interest. C. During 8th BPS, the DA anomaly was removed with effect from 2005 for the pensioners who retired between 1998 to 2005, but the arrears were denied to the pensioners who retired between the period 2002 to 2005, which was violation of Supreme Court orders. D. Supreme Court has held that no agreement or joint notes executed between unions and management has right to take away the existing right or benefits, especially joint notes executed with officers associations who were not eligible under the Industrial Dispute Act 1947 has no force of law. Thus, no decision can be taken against the basic rules of service conditions and statutory provisions. E. The relevant para 29 of the said judgment is reproduced for your ready reference. In our opinion, the regulations which were in force till 2003 would apply with full force, and as a matter of fact, the amendment made in it by addition of regulation C in regulation 2S did not have the effect of amending regulations relating to pension as contained in stipulation in regulations 38 read with regulation 2D and 35 of the regulation 1995. Even otherwise, it had effect of amending the pay and partial average emoluments as specified in regulation 2D. It could not have operated retrospectively and take away accrued rights, otherwise also it would have been arbitrarily exercise of power. Besides, there was no binding statutory forces of the so-called joint note of the officers association as admittedly to officers association. Even the provision and Industrial Dispute Act were not applicable, and joint note had no statutory force, and it was not open to force the benefit available under the regulations. To these officers who have retired from 1st April 98 till December 99 and to deprive them of their benefits of the regulations, thus by joint note that has relied upon no staple said to have been created as against the enforcement of the statutory provisions. The joint note has no force of law and could not have been against the spirit of statutory regulations and the basic service conditions as envisaged under the regulations framed under the Act 1970. Though could have tinkered with an arbitrary matter as they have laid down by this court in the Central Inland Water Transport Corporation and an NRV versus Bro No Nath Ganguly and NR 1986 3 SCC 156 and Delhi Transport Corporation versus DTC Mazdoor Congress 1991 Supplementary 1 SRC 609. F है. It is crystal clear from above that unions and IBA cannot take arbitrary decision violating the provisions of Pension Regulation 1995. G. I found that it is provided under the Article 19 of the Constitution of India that the labor employee have right to form unions to fight and demand for better wages, service conditions and other benefits. They have no right to agree to curtail the existing rights. Supreme Court has held both ways. Neither the unions can agree to curtail the existing right nor it can agree to reduce the monetary benefits with retrospective effect. G. The crux of the message is that employees, unions and IBA cannot take away an existing right by merely singing an agreement/joint note. During previous settlements, all decisions taken are arbitrary and unlawful in violation of provisions of Pension Regulation 1995. As such decisions are serious violation of SC directions. Our senior leaders should take notice of these observations and write to the IBA as well as banks to stop such malpractices of taking decisions to cause financial loss and mental harassment to the pensioners. H. The banks should not surrender their right to implement and to make any desired amendments the Pension Regulation 1995. They should also revisit the Memorandum of Settlement of 1993 and introduce the clause of updation on the lines of RBI as assured by IBA and later on recommendations by a small committee constituted to frame detailed regulations. All friends, union leaders and activists should read the judgment dated 30th February 2018 carefully referred by me, in which there are many historical observations made by Honorable Supreme Court which may help us to fight for our legitimate rights. Thanks, रमेश भटेजा। तो ये था रमेश भटेजा जी का, इन्होंने बहुत सही और अच्छा लिखा है और इन्होंने कामना करी है कि भाई सभी लोग इसको देखें और पढ़ें और इसको आगे तक पहुंचाएं। और ये सही भी है, हमें ये सब करना चाहिए उस हिसाब से। धन्यवाद साथियों। भारत माता की जय। वंदे मातरम। आर के त्यागी। गाजाबाद।